Well, good morning, everyone. Welcome to Georgetown Law. I'm Bill Traynor, the Dean and Executive Vice President of the Law Center, and I'm privileged to welcome you to this conference at a key point in our constitutional history. As a constitutional historian, I must say that we are in for an extraordinary discussion. Constitutional amendments are rare, but they represent some of the most important moments in the history of our democracy. The ERA represents a long overdue recognition that a majority of our citizens have been denied formal recognition in the document other than in the right to vote. This sullies our collective vision of our nation as a democracy, and it hinders Congress in protecting gender equity. And this could not be more important than at this moment in our history, when the Supreme Court has made clear that it is skeptical of gender equality and major change is afoot. Although constitutionalists tend to focus on courts, this is a moment where the Constitution tells us that Congress plays a key role. And we are blessed to have several members of the congressional forces from the House and Senate leading us to resolve key questions on the Equal Rights Amendment. Today's conversation with extraordinary constitutional scholars and lawyers will highlight an amendment first introduced over 100 years ago, an amendment which has now been ratified by 38 states, which is the key constitutional requirement, but remains subject to a variety of procedural challenges. Later today at lunch, you'll hear from Senator Ben Cardin, who has led the fight in the Senate, and Representative Barbara Lee, a leader in the House. And you will hear either virtually or in person, depending on the votes, from House members Cori Bush and Ayanna Pressley, who are co-chairs of one of the largest caucuses, the ERA caucus in the Congress. You'll also hear from Senator Gillibrand, who will make a virtual appearance later in the day. Senator Booker has sent us a statement, and Senator Hirona, who is a Georgetown alum, class of 78, will attend our founders reception after the conference for invited guests. So I'd like to thank the law firms of Winston & Strawn and Covington and Burling for helping us put on such a remarkable conference where constitutional law and Congress will meet in dialogue. And I'd like to particularly acknowledge and lead us all in a round of applause for the masterminds of this event, who I will call to the stage after me, Professor Catherine Franke of Columbia Law School, the head of the ERA project there, and Professor Victoria Nurse and the Congressional Studies Center at Georgetown Law and their teams, Professors Nurse and Franke.
Thank you so much to the Dean and to all of you who are here. A few years ago, I got a call to testify at the House of Representatives on the ERA. And I have to say that there are people here like Professor Franke and others on this panel who know a lot more about the ERA than I did at the time. And I testified, and what I testified about, though, came from lived history, which is to say that I knew a lot about constitutional methodology. That's what I teach. I also knew a lot about gender equity, and it was personal. Many years ago, when I was a baby lawyer, I worked for a senator named Biden, and I helped write something called the Violence Against Women Act. And in 2000, the Supreme Court struck down what now President Biden calls the heart of the law in a case called United States versus Morrison. So the good news is I brought a lot of passion, if less knowledge, to the House hearing, and it got on TikTok. Wow! My daughter was suddenly and newly impressed by her mother. But you're going to hear a lot today about the ERA, and I have come to believe, in part due to my co-conspirator over here, Professor Franke, that this is a generation-changing amendment, and that it is, as Dark Brandon would say, a BFD. It covers a variety of things. It's about gender equity, gender minorities. We'll see about the intersection of race and sex. And this court, since I write about textualism and originalism, will only listen to us if we are in the text. Thank you very much. And I want to give you the real mastermind behind this, Professor Franke.
Thank you, Vic. Stand back up here with me. So in so many respects, I consider myself today to be playing Ken to her Barbie. I'm just Catherine. And I just want to thank our hosts here at Georgetown Law Center, Law School. It's just so wonderful to be back in DC. And really what we're trying to do today is have a conversation about how to finalize the ERA, where we won't all agree about every point. When you bring together a group of scholars, inevitably you'll find disagreement, but I believe we're all rowing in the same direction. And so our aim for today is to take a deep and thoughtful dive into the remaining issues that stand in the way of broad acknowledgement that the ERA is the 28th Amendment. And then in the afternoon's program to talk really critically about what the ERA should do. What will it mean to have the ERA? And what are the different options that are sort of on the table for what the ERA would do other than what the Constitution is already doing through the 14th Amendment to protect sex-based equality. So those are some of the ambitions for the day. Let me just say it's so wonderful to have so many of our partners in this work here, virtually and in the room. The ERA Coalition, of course, now the Feminist Majority, Vote Equality US, the Young Feminist Party, right on Young Feminists, National Women's Law Center, and so many others. Thank you so much. And also for the support from law firms, Covington and Burling, Winston and Strawn, and Venable, who have supported today's events, and some of whom are here with us today. Thank you so much for your partnership in this work. And then specifically to the events team here at Georgetown. We are so in awe of the way you guys put on a show here at Georgetown, and are quite envious at just what amazing machine and just what kind people you are in welcoming us here to DC and to Georgetown. So before we begin our first panel, we're going to have some opening remarks from Representative Jennifer McClellan, who's the member of Congress from the 4th District of Virginia. You surely know, if you care about the ERA, that she led or was among the leaders of the effort to bring Virginia across the line as the last state needed to fully ratify the ERA. She's the first Black woman elected to Congress from the Commonwealth of Virginia, and she's vice chair of the Congressional ERA Caucus, a true leader on issues of sex equality, race equality, economic justice in Virginia, but nationally as well, too. So let's cue the tape, as they say, and hear from Representative McClellan.
Greetings, everyone. I'm Congresswoman Jennifer McClellan, and I have the privilege of representing Virginia's 4th Congressional District in the United States House of Representatives. I am the first Black woman elected to Congress from the Commonwealth of Virginia. I am the daughter, granddaughter, and great-granddaughter of educators, domestic workers, community leaders, and civil rights activists who struggled for equality in the Jim Crow South. My great-grandfather was born shortly after the Civil War on a plantation where his parents had been enslaved. Shortly after Reconstruction, he had to pass a literacy test and find 3 white men to vouch for him just to be able to register to vote. But my great-grandmother couldn't vote. My grandfather and father had to pay poll taxes to cast their ballots. My mother comes from generations of domestic workers who were often overlooked and underpaid despite the vital role they played in our society. And while my father voted at the age of 22, my mother couldn't vote until well into her 30s after the passage of the Voting Rights Act of 1965. My family faced tremendous obstacles to exercise their fundamental right to vote. Yet they never wavered in their commitment to our political process or their desire to create a better future for the next generation. Throughout my nearly 2 decades in elected office, I have carried these stories with me, Stories that motivate me to do my part to build a more inclusive, tolerant, and just future for my own children. When I entered the House of Delegates in Virginia in 2006, I was one of just 20 women in that chamber, out of 100. I felt that imbalance when I became the first delegate to become pregnant and give birth while in office. I was asked by a male colleague, "Are you going to retire?" Yet another male colleague who became a father 2 months after I gave birth was not asked that question. It has been a long march for gender equality under the law, a march propelled by abolitionists, the civil rights movement, the suffrage movement, and the women's rights movement, which from the very beginning included women of color on the front lines, even when we were at last to benefit from that work. Black women, including the founders of my sorority, Delta Sigma Theta Incorporated, in their first public act, marched for the right to vote in 1913, even when told to march in the back. Black women marched for civil rights in 1963 from the U.S. Capitol to the Lincoln Memorial, even when not given a speaking role. Throughout the course of history, Black women have been integral to the fight for equality. We laid the groundwork for progress while overcoming tremendous obstacles. We did our part. And I am fighting to continue doing mine. While in the Virginia General Assembly, I was part of a multi-generational group of Black women lawmakers who came together to make Virginia the 38th and final state needed to ratify the Equal Rights Amendment. And it was poetic justice that our Commonwealth, the birthplace of American democracy and the birthplace of American slavery, was the state to bring the ERA across the finish line. It was a feat that the first women to arrive in Jamestown 400 years earlier could never imagine. In 1619, the men of Jamestown realized that they needed women to make Virginia a permanent settlement. So they actively recruited women to, quote, make wives of their inhabitants. And in 1620, the first 90 women arrived on the shores of Virginia, and their rights were surrendered to their husbands. They could not vote. They could not own property. Black women were considered property and had even fewer rights. 156 years later, Thomas Jefferson wrote in the Declaration of Independence that all men were created equal and endowed by their Creator with certain unalienable rights, including life, liberty, and the pursuit of happiness. Thomas Jefferson most certainly did not include me in that declaration. 72 years later, Elizabeth Cady Stanton wrote Women in the Sequel at the first Seneca Falls Convention. In the Declaration of Sentiments, she wrote that all men and women were created equal. In 1787, the Constitution created a government by, of, and for we the people, but we did not include everybody. It took 81 years to begin extending that promise beyond white men. In 1868, the 14th Amendment promised equal protections under the law, but women still did not experience that reality. In fact, the 14th Amendment added the first mention of gender into the Constitution, declaring all male citizens over 21 should be able to vote. It took another 52 years for the 19th Amendment to grant women that right. And 3 years later, the Equal Rights Amendment was introduced. And we are still fighting to publish it in the Constitution. The states have done their part, and I was proud of my role in that fight. Now in Congress, I am still fighting to enshrine gender equality under the law into the Constitution. As a vice chair of the first ever Congressional ERA caucus, as the first Black woman to represent Virginia in Congress, and as a mother to 2 young children, I will continue fighting to do my part so the next generation is not left fighting the same battles that our mothers, our grandmothers, and our great-grandmothers fought. As we witness widespread, systematic attacks on reproductive freedom, access to the ballot box, and other personal freedoms, it is imperative that we take immediate action to make gender equality the law of the land. This Congress, I signed a discharge petition to demand an immediate vote on ERA caucus co-chair Ayanna Pressley's resolution to remove the arbitrary ratification deadline for the ERA and enshrine it into law. I will continue my efforts until the ERA is published as the 28th Amendment to the United States Constitution, because we owe it to our daughters and our granddaughters, as well as our mothers, our grandmothers, and great-grandmothers. I thank Columbia Law School and Georgetown University Law Center for your work on the Equal Rights Amendment project and for creating space for today's discussion. Together, we will continue doing our part in the march for gender equality under the law.